I'll proceed in a fourfold manner. One will be to kind of reiterate what a Christian lawyer should look like, how they should act, and then I'll get into the second topic, which will be the underpinnings of law. What are the four types of law, and how should they inform us on how to present cases in court? The third section will be engaging bodies and courts on Christian issues. I think as participants in this conference, we have a vested interest in what's happening to Christians around the world, and perhaps particularly here in Europe. And then finally, I want to talk about the 5 key issues that are facing Christians, the ones that I identify anyways, working on these issues for Alliance Defending Freedom. And I'll get into them briefly before getting into about a half an hour question period. So as part of the presentation, I have some handouts here. And I'll just warn you, these are privileged. This is why I don't have them on PowerPoint. So our good people watching can't see them, but here we go. So please, when you, if these aren't useful for you, please discard them, and please don't distribute them to others. Right now, they're still a work in progress, and we certainly don't want our opponents getting a hold of them. ADF, in compliance with American regulations, has now deployed drones to make sure that you will not use them improperly. So I want to start briefly about what it is to be a Christian lawyer. Scripture has a lot to say about lawyers, and to be honest, a lot of it's not nice, especially in the Gospels. But there are, Paul definitely was someone who used the law. He knew he was a Roman citizen, and when it came time to be brought to trial, instead of being locally punished, he demanded to have the rights of a Roman citizen. He used the law in a proper way. The Old Testament, of course, is all about the law. Proverbs has some great quotations. Just Proverbs 31, 8-9 says, "Open your mouth for the mute, for the rights of all who are destitute. Open your mouth, judge righteously, defend the rights of the poor and the needy." And then again in Proverbs 24:11, "Rescue those who are being taken away to death. Hold back those who are stumbling to the slaughter." Those are great, great verses for the lawyer. It's one of the reasons I got into human rights law, and something I'm sure that most of us got into a lot of practice. And for those who are more into transactional law or corporate law or other forms of law, there's always pro bono work, and not just that, but there is a way to do your practice as a Christian, as a missionary and a message to others. And just, I always think of it as a twofold thing. You are a Christian, live as a Christian, live out the gospel. That's a much stronger message than words can convey, because if your actions aren't commensurate with your words, then you're doing a disservice to the gospel. If you're living a life that is really blameworthy, if you're slacking on the job, if you're cheating on hours, if you're doing stuff like that, but you're engaging your colleagues in the message of the gospel, it's a real mixed message. So I really would encourage you to really live out the gospel as best you can. And on top of that, you have the added extra burden. I think as Christians, we need to be better at the law, better versed technically in the law than our opponents, because we do have a bad reputation sometimes. We can't go into a courtroom and start quoting scripture. There are very limited circumstances where that is the case. For example, if you're defending if you have a reasonable accommodations case and you're defending someone's right to conscientiously object to performing certain work and suggesting they have a sincerely held religious belief, well, then you can use scripture to back that up. But in most cases, you need to translate. You need to translate scripture and natural law into public policy and law. And there are ways to do that. And I'll discuss that by getting into the underpinnings of law. A law, I define it I don't define it. It's defined classically in a fourfold manner. It's an ordinance of reason, that's number one. So it's part of the eternal law, something that's conveyed through reason for the common good. That's the second element. Made by him who cares for the community. So in a democracy, that would be a legislature. In a European Union democracy, it would be faceless bureaucrats in Brussels, but I'll leave that for another day. And number four, promulgated, meaning properly enacted. And the European Convention of Human Rights has several elements which are in regard to promulgation. Whenever they talk about a violation of a human right, the first step, it's a three-pronged test. The first is that law properly promulgated? Is it prescribed by law? Is there requisite clarity, foreseeability? Is there precision to it, meaning that there's not an unfettered discretion for the local authorities to run amok and arbitrarily decide your rights? So that's a key factor of what a law is. Now, the second element, the law must be for the common good. Now, we've really run astray, I think, in the past generations in how we define common good, because we've taken the common element of it, where we've become really individualistic, and law has become individualistic, and we've seen that, and I'll get into that a little bit later, but we've seen an inversion of rights. We've turned privileges into rights, and through those privileges, we've really trampled traditional fundamental rights. But the definition of common good is, again, three elements. The sum total of social conditions. Second element, which allow people, either as groups or as individuals. Third element, to reach their fulfillment more fully and more easily. I'll repeat that. The sum total of social conditions, which allow all people, either as groups or individuals, to reach their fulfillment more fully and more easily. So, law is a rule and measure of acts whereby man is induced to act or is restrained from acting. There is no such thing as an immoral law, in a sense. Now, we define morality differently, but I challenge anyone here to tell me one law that's not moral in nature. Even speeding regulations, as much as I dislike them, have a moral nature. They're to keep people safe. Now, there are four elements of law. The first is eternal law. That's God's law, the divine ordinance of all things. The second area of law is divine law. That's God's revealed law, which includes the Old Testament and the New Testament. Of course, the Jewish tradition looks at the law as a gift, and I think that's rightfully so. I think we sometimes, I'm a grace guy too. As Christians, we're people of grace. We know that love is the highest law, and that we can't fulfill the law without grace, and we're saved from the law by grace. But the law is still a gift. If you think about it, it's kind of like a car manual. Car manual says don't put oil in your gas tank. Why? Because if you put oil in your gas tank, the car's not going to run well. Well, the Old Testament says do not commit adultery, do not murder, don't do this, don't do that. It doesn't sound like a lot of fun sometimes, but if you follow that, your life will function properly. And the fact that God gave us a gift, gave us an ordered way of running our lives is really a tremendous thing, because it shows He loves us like a father loves children. Now, sometimes, like children, we rebel against that. And so there's a third element of law that God gave us to help us along the way, and that's natural law. So as Paul says, this is a law that's written on our hearts. It's our conscience, in a sense. So a well-informed conscience is a better conception of natural law than, say, a heart that's guided towards evil. Natural law has a share of the eternal reason, whereby it has a natural inclination to its proper act and end. And this participation of the eternal law in the rational creature is called the natural law. And finally, there is human law. Now, human law, again, here's another quote, can be described by stating, it is from the precepts of the natural law, or should be from the precepts of the natural law anyways, as from general and indemonstrable principles, that the human reason needs to precede the more particular determination of certain matters. These particular determinations devised by human reason are called human laws, provided the other essential conditions of law are observed. So I want to briefly get now into the difference between legal positivism, which is really kind of the law that's being taught in most universities today, and natural law. And again, this has been a major shift. When we look back at the creation of the major human rights instruments back in the 50s, the Universal Declaration of Human Rights, the European Convention of Human Rights, and the ICCPR, those are real natural law documents. Now, there was argumentation at the time between positivists and natural law theorists on what kind of document it was going to be, but I really believe that at the end of the day, the natural law theology won out. And the reason I think that positivism, it's one of these Austrian things. Hans Kelsen was an Austrian, and it's very strict in the sense that if you have a legitimate government, and legitimate is very liberally interpreted. So you can say Hitler, because he was a legitimate leader, had a legitimate power base. And if a law is duly promulgated by that lawmaking body, then that law is valid. Now, the problem I have with natural law is that suggests that Nazism was correct and the Nuremberg trials were wrong, because Nuremberg was usurping and questioning the role of a legitimate government in that sense. Natural law, on the other hand, would say what was happening in Germany was absolutely abhorrent. So there, that's where you get in the distinctions. And Aquinas said that law cannot promote every virtue, and it cannot forbid every vice. And Romans goes on and says, "I do what I hate because of the law." So when you overdo the law, of course, it leads to a kind of rebellion of the heart. And I think that positivism lends itself to overregulation as well. And we see the European Union does all sorts of wacky stuff. They have the famous, the banana regulation, where they regulated the shape and the size of bananas. What for? I mean, seriously. Solzhenitsyn, who's a great author, very well respected in these parts particularly, wrote that there's no such thing as a bad guy. A guy, the guy with the black cowboy hat riding on the black horse. He thinks that ideology poisons people, but that people wake up not thinking they're doing evil, but they've been poisoned by their ideology. And all ideology has a kernel of truth in it. So even our opponents, when they're dealing with abortion, same-sex marriage, they do believe what they're doing is morally good in their eyes. They believe it's equality, or they believe that they're really defending women's rights. When these are taken to their natural logical conclusion, however, we get things like Planned Parenthood, which is a billion-dollar industry which makes its money killing unborn children. So ideology is really, it's the leading killer in the 20th century. We see Rwanda, we see Auschwitz just literally down the road from here, all because of ideology. So we have kind of forgotten the eternal law, and natural law has been lost along the way somewhere. Now I think that one way as Christians, we've been asleep at the wheel too long. And when Alliance Defending Freedom started back in the 90s, it was kind of 20 years late on the scene. A lot of the rights that Christians had enjoyed in America had already eroded. It all started with school prayer, and that's not just unique to America. I know in Sweden, when they wanted to get rid of school prayer, they had 1 million people. This is a country of 10 million people. At that time, it was much less than 10 million. 1 million people signed a petition to keep prayer in schools. And kind of like in France, they ignored it and took it out. And we see how Sweden is morally deteriorated, and how they are kind of the radical model of everything we oppose on a lot of issues, with minor exceptions. I know they have a great anti-trafficking laws and great anti-prostitution laws, but with regards to other elements like abortion, you can't even question that abortion isn't a fundamental right in Swedish schools. I had a client once who was basically thrown out of his master's program because his dissertation was questioning abortion as a right. So it's really radical stuff. And I think that with that lapse of engagement, we weren't losing because the law wasn't on our side. The law absolutely was on our side, but we weren't engaging. So we were losing by default. We weren't coming out of the game. And in the United States, anyways, we had gained a lot of ground back since the 90s. We've kind of dipped as a result of the Obama administration and lost certain rights again. In Europe, it's rather a new phenomenon. The defense of Christian rights came much later than that. And again, our opponents have been here for decades. I read a memorandum from the early 80s from ILGA, It's a homosexual agenda organization from Austria, talking about electing judges to the European Court of Human Rights would be favorable to their views. This is stuff that we're only doing today. So we're way behind. And we see it in the cultural battle because we've been on the losing end in unprecedented ways in the last 2-3 years. It's really, to be honest, it's shocking because, you know, my case history anyways, for the last 10-11 years, we were winning everything. And in the last year or two, it seems like we can't pull out a victory except in really the egregious church registration cases. So they're dangerous times, and that's why I wanted to switch a little bit and talk about how we as Christians can engage. Now, again, this could be for those who are professionally engaged in religious freedom. It could be those who are interested in pro bono, or those who just, you know, in their spare time want to engage in a really de minimis manner. The organizational chart, which actually I don't have a copy of. Can someone give me a, do we have? Thanks. Let's start with the European Institutions chart. Now, the reason why this one, I think this one's really accurate. The reason we don't want this to be distributed is because it would hurt us in our influence with the institutions here towards the lockup. Because no one wants to be working for a lower level institution. And in a sense, it's not fair to call them institutions of less importance. I'll tell you why we've organized it in that way. This is organized from soft law bodies to hard law bodies. Now, soft law is not law that can be brought to court. It's not law that can be used on a day-to-day basis. It's really legal recommendations. So the Council of Europe and the European Parliament pass resolutions all the time, and we fight about them because they're important. And the reason they're important, well, there's several reasons they're important, but there's something called Customary International Law. That when you repeat a term over and over and over again in soft law, it will eventually become hard law. And so when we look at the UN treaties in particular, they use this term sexual and reproductive health. It is used everywhere, absolutely everywhere. It's never been defined to mean abortion, but it's getting there. And the UN institutions internally are using it to mean abortion. So they are well on their way to creating a universal right to abortion through this language. So this is, they do have an important role. Let's take the Parliamentary Assembly of the Council of Europe. Their resolutions. Recently there was the McCaffrey report on conscientious objection. Now that's a soft law document. It means that it's not something that you can go, if you're in Sweden or Norway and you're being told you have to perform an abortion, you don't have a right to conscience, you can't pull out the McCaffrey report and say, yes, I do. But when you go to court, you can file it as a persuasive argument. And McCaffrey has really caught fire. There was recently, and we assisted with this, a complaint filed with the European Committee of Social Rights challenging Sweden very much on their inability for doctors to opt out of abortions based on conscience because of McCaffrey. So this we're hoping will take on, along with other elements, hard law. Now, I'll just go through some of these institutions. Fundamental Rights Agency, I'm a member of their advisory panel, an elected member of their 9-person advisory panel. They're a European Union charter body, and they're meant to engage on issues in the interpretation and the promotion of rights under the Charter of Fundamental Rights. They are just about the worst organization in all of Europe. And really, you have to see it to believe it sometimes. Their publications are awful. When it comes to hate speech, for example, they define hate speech to mean all sorts of different things in different publications. In one section, they even say, speaking about religious speech, while this stuff legally isn't hate speech, we're going to label it here as hate speech just for the sake of argument, and then they go forth and do it. They recently did an LGBT study, anonymous, so you can call in 20 times if you wanted to. And they're claiming, based on this evidence, that now they have found that 1 in 4 practicing homosexuals has been a victim of a hate crime. And they're using this at the European Parliament. There was a grand launch at the Hague. This is absolutely unverifiable evidence. And the fact that they're using the term hate crime, which of course, as lawyers we know, as a legal crime suggests that there's been files charged and a prosecution, a successful prosecution, for it to be a hate crime. Well, certainly not a hate crime. Now they can say that one in four participants of the study suggested that they had violence against them. Even there, the American Bar Association did a great study which suggested that 33% of all same-sex relationships have violent elements to it. So was that factored into the study? Child abuse is a huge factor among many who later self-identify as being homosexual. Was that included in the study? So, I mean, their suggestion is that people are being beaten up because they're practicing homosexual. And that is now going to be used to form policy and law. So even though it's here at the bottom, it's a very, very serious entity. Now, ODIHR is down here as well, the Office for Democratic Institutions and Human Rights. It's one of my favorites because I like saying ODIHR. It sounds really sweet. It's a Warsaw base. It's based here in Poland. But they hold a lot of events in Vienna, where our office is, and they hold a 2-week event in Warsaw, Poland every year. And it's a great event. I would suggest if you're a member of an NGO, please attend, because, again, for years, Christians weren't showing up. And the stuff that was coming out of ODIHR was awful, absolutely awful. And that stuff becomes the policy, even though it's being shaped at the bottom of the period, that stuff filters up. And so it becomes hard law eventually through court cases, through, it'll go through the UN, through the EU, and it'll eventually become hard law. And they were dealing with stuff like opt-outs in school, parental rights, the right to manifest religion. And I remember, does anyone know the ACLU? They're our chief opponents in the United States. A hugely well-funded organization. They take baths in golden bathtubs, and the pillows are stuffed with money. It's really terrible people. And I'm on camera saying that too. But Jeremy Gunn, who's one of their top people, was the expert for the religion and belief experts session the first time I ever went to the OSCE. And basically what he was saying was, oh yeah, we can't use the word Muslim terrorist because that should be a hate crime, because just because you're Muslim doesn't mean you're a terrorist. Oh, and by the way, Christians complain too much. The only real division in Christianity, the only real intolerance among Christians is between Catholics and Protestants. So this was the expert on religious freedom at the OSCE. So, I mean, since that time, the Holy See, the Vatican, has been great. They've really engaged a lot of ecumenical effort for Christian organizations, evangelical organizations, as well as Catholic organizations, to come. And the whole flavor of the OSCE, the whole culture of the OSCE, has changed in a matter of 3 years. So it just shows how you can really turn around an organization. Now at the top, we have, I'll just talk about the top 2 levels. There's the European Parliament, UN Human Rights Council, the UN Human Rights Committee. Now, the 2 UN bodies I put there because they have complaints mechanisms. So even though they're not specifically courts, you can file complaints with them. And the European Parliament, while they do the soft law resolutions, they're also in the co-decision procedure when it comes to making the directives and the regulations of the European Union. And the vast majority of our law, whether we like it or not, comes from Brussels these days. And at the very top, I put the hard law bodies. So the European Court of Human Rights. They are the court for 47 member states. Lord Mackay was talking about the cases of Nadia Ouida and Lillian Lidelli and Gary McFarland the other day, and I'm sad to report that the appeal wasn't granted. It was turned down. And I'll talk about anti-discrimination law very, very briefly because he did an excellent job on it towards the end of my talk. But it really leaves the state of European jurisprudence with regard to how Christians can act in the workplace in a very dangerous place right now. The Court of Justice of the European Union, that's something that's a lot more difficult to engage in. It usually takes the form of domestic courts sending preliminary questions up to the Court of Justice and them answering. But there's been some amazing decisions that have come out of the Court of Justice of the European Union recently. I mean, shockingly good. The most positive was the Bruce Ley case, which was an embryonic stem cell patent case, where for the first time ever, an intergovernmental court said that life begins from conception. So, I mean, wow, what a powerful precedent, because there's no other intergovernmental court that said the opposite. Now, it's specifically within the realm of patent law, but my goodness, is that ever persuasive in other contexts as well? They've also dealt with religious manifestation. The Advocate General in an asylum case held that the right to religious freedom, of course, means external manifestation. So it's not just a private realm. And that helps us in cases like McFarland and Liddell, because it shows that you can bring your faith to work. I mean, religious freedom to me means the right to preach the gospel to your neighbors, to bring your faith into the classroom, to the university, because without those abilities, without the freedom to live out your faith, express your faith, then religious freedom is really dead letter. And unfortunately, that's where we're at right now. We're at a place in time where they're trying to limit religious freedom to freedom of worship. And we've heard it in political speeches where they no longer talk about religious freedom, they talk about freedom of worship. And it still sounds the same. It's not. Freedom of worship means the right to worship in your church, the right to hold private views, but not to bring it out into the public sphere. So in employment, even in the public square, you have to keep your faith private. And the UK government, in its submissions, I would have laughed at this if it wasn't true, but they defined religious freedom in the McFarland brief, in these anti-discrimination cases, as the right to quit your job if you have a conscientious crisis with something. So that's UK, one of the great democracies. And no offense, guys. I love the UK. UK has some of the greatest legislation, in the world. Its anti-discrimination legislation, however, is troubling, and it gives us a sense of what Europe could look like if a directive called the Equal Treatment Directive is implemented. And again, I'll get into that towards the end. Let's switch now to the other chart. Now, this is kind of the how to engage document. It's color-coded. Purple means advocacy. So it doesn't mean direct litigation. It means being able to advocate on your behalf. So policy arguments, being able to take part in roundtable discussions. The yellow is written and oral submissions, and those are really incredibly helpful. Something like the OSCE, it is one of the best venues for kind of your hobby human rights person, because you go in, you can put in an oral submission, it goes on the OSCE website for the whole world to read, and it kind of has this official stature to it once it's on the OSCE website, and then everyone has the same possibility to make an oral intervention, as do the countries. So you all sit around the same table. The first row are the country delegates, and there are 70 countries within the OSCE, and then around there's another circle around them of NGO representatives, and you just lift up your hand, or in some cases you sign up before the session, and you get your 3-minute intervention. And when you have several Christian organizations who get together beforehand and say, okay, we're going to talk about anti-discrimination this time, or church autonomy this time, then it gets into the official notes, and it starts becoming policy. So these are really great methods of getting engaged and changing, soft law into hard law. Then green is accreditation. So these are bodies that you can become accredited with. Fundamental Rights Agency is an obvious one. It's a pretty easy one to get accreditation for. European Parliament is also fairly easy. United Nations consultative status with the Economic and Social Council, it's much, much, much more difficult to get. There's a lot of politics at play, but it really is an invaluable tool. And it's used well by a lot of great Christian organizations. And the question of, and finally, direct litigation is blue, and those are also complaints procedure. And there are 9 international human rights treaties, and all 9 of them have treaty monitoring bodies. And most of those have optional protocols which allow you to bring official complaints, so almost like court cases. And a lot of them don't require domestic remedies to be exhausted like they would at the European Court of Human Rights, for example. Then there's one charter-based body in Geneva, the Human Rights Council, which has a complaint complaints procedure. On top of that, there is the Human Rights Committee, also in Geneva. The UN, they like using the word human rights, and it gets confusing sometimes, committee, council. But it polices the ICCPR, the International Covenant on Civil and Political Rights. Now that document is remarkably similar to the European Convention on Human Rights. And in fact, if you look at the legislative history, the Travaux Préparatoires, sorry, my French is awful. I lived in Strasbourg for 3 years. It didn't rub off. But the legislative history suggests that a lot of the, you guys speak French, so you can tell it was bad. But the legislative history shows that a lot of, especially the right to life and several other elements of the European Convention were taken directly from the debates of the ICCPR. And they have a complaints body which has really the effect of law. They don't have the teeth to really follow through on their judgments, but sadly, neither does the European Court of Human Rights. When a case is finished in Strasbourg, it stops at the court and it's sent to the Council of Ministers for enforcement. And that enforcement is really lackluster. The really thing they can only do is add interest to fines that are given and suspend the country, which I think they've done once briefly in the history of the Council of Europe. So it's not really a great mechanism either. So countries do tend to follow through at both the European Court and the Human Rights Committee just because of diplomatic scrutiny. So again, it's a great mechanism, especially for those who aren't in Europe or those who don't trust the European Court of Human Rights. If you come from a country which has huge rule of law problems and the courts are really backlogged, including the European Court, so a country like Russia, for example, if you file with the European Court, it's going to take about 8 years, generally, to get your claim heard, just because there's such a huge amount of claims in Strasbourg against Russia. So one viable choice would be to go through the Human Rights Committee. Now, why engage through advocacy in these international bodies? And I'll give you 5 reasons. One is abortion. I talked about it before. Abortion as a human right. So the destruction, the killing of the unborn child is now considered a human right. And this is a sidebar on that. Again, I think there was a case in the United States Supreme Court in the 50s called Griswold v. Connecticut. It was dealing with the right to contraception. And the Supreme Court of the United States did something very clever there. They created a right of privacy. So if you read the Constitution of the United States of America, there is no right to privacy written there. It's in the European Convention of Human Rights. It's not in the American Constitution. So they said, within the shadows and the penumbras of the Constitution, kind of this magical thing. If you look, hold it up to the light, rub a lemon on there, and you can see in the middle of the lines there, it says privacy somewhere. They created a right to privacy, and basically what they had was they didn't have a legal basis to protect contraception, and so they created one. And the poisonous fruit of that precedent led to Roe v. Wade a few years later. It led to late-term abortion being upheld. It led to Lawrence v. Texas, which was the sodomy laws, the anti-sodomy laws in the United States being brought down. One bad precedent led to all this evil fruit. So, again, this is why we need to be engaged legally in this culture of death. But there's a great document called the San Jose Articles. I really recommend that all of you Google it and read it, because it will give you a picture of how far astray this has gone. Now, even though sexual and reproductive health is in a lot of these documents, not once has a UN document ever said that it meant abortion. Now, there's one protocol, an African protocol, that mentions it includes abortion, but more than half of the countries to that protocol either didn't sign it, they didn't ratify it, or even more of them had reservations with regard to that element. And so it became a useless document as well. So there is no international right to abortion. Yet, you hear this term over and over again, and when an abortion case gets sent up to Strasbourg, well, my goodness, it gets heard within 6 months. It goes to the Grand Chamber. ABC v. Ireland, which is to me one of the great scandals of European jurisprudence, they had a case several years ago called D v. Ireland, which was the case of a mother who had her child was diagnosed with a severe disability, and she wanted to get an abortion. Now, the European Court of Human Rights said, okay, first of all, she went directly to Strasbourg without exhausting domestic remedies, which is a key element of the convention. The court said remedies were available in Ireland, and they should have been followed through, and that they dismissed the case. So a very similar case with 3 anonymous women, and all of these women in these abortion cases are anonymous because maybe they don't exist, or they're just people who want to get a paycheck from Planned Parenthood or Center for Reproductive Rights. They don't show up to the oral hearings, so we don't know if any of them really exist. But they're always incredibly sympathetic on the facts, as if they just kind of came out of manna from heaven in a sense. But same facts, no exhaustion of domestic remedies, and instead of being dismissed, it was brought to the Grand Chamber of the European Court of Human Rights. The highest level of the European Court of Human Rights heard the case and found Ireland in violation, saying that they need to legislate on abortion. Now that has been used politically, because as I said, the European Court, all they can basically do is levy a fine and say, review your legislation. Ireland, the political forces within took it a step further, and for the first time in Ireland's history, they have a law before their parliament trying to legalize in some aspect abortion. They're trying to legalize the X decision, which is an exception to their abortion prohibition. So we need to be vigilant in fighting these elements and reminding these bodies that abortion is not a right. The second element is sexual orientation and gender identity as a human right. We all know about that. Just a year ago, it seems, before the last election in the United States, I was in Madrid at the World Congress of Families giving a speech on marriage and saying how great everything was. And it's amazing how times have changed in less than a year. I was able at that time to say that there's been more than 40 referendums on marriage, some trying to redefine marriage, others trying to hold marriage as between just one man and one woman and make that a state constitutional right. Every single time, up until that election in the United States, traditional marriage won. Even in Slovenia, they had a referendum on adopting same-sex marriage or civil partnerships, and they worded it in such a tricky way that it seemed like you couldn't win. And so what the Slovenian people did was they didn't show up. And so they didn't meet the threshold for the referendum, and it failed. But the times are changing. 2 states, by referendum in the last election, ratified same-sex marriage in their state constitutions. France was the latest to fall, Denmark before that, and the UK, I'm not going to say it's inevitable, but we need a lot of prayer and a lot of effort in the UK to keep it from happening. So they have been incredibly successful with their lobby. And that lobby, if you look at your pyramid, every element of that pyramid, that lobby is present. And they've been present for years. And in a lot of their cases, there are UN bodies whose commissioners and secretary generals are people who work for Planned Parenthood and the Center for Reproductive Rights, or for ILGA, or for any number of homosexual agenda organizations. So they are engaged. We need to be too. Third is defamation of religion and related hate speech issues. The United Nations is trying to make Islamophobia and criticism of Islam a hate speech crime. And a great example, some great examples, one though is in the United Kingdom, a bed and breakfast owner got into a lively debate with a client about Christianity versus Islam. And the Muslim who had initially engaged in the debate was offended and went to police, and a hate crime was filed. And this was litigated for a number of times. Even though these bed and breakfast owners, at the end of the day, were vindicated, they lost their business because of the legal expenses. So one frivolous complaint and lives were ruined. Another crazy example would be, in Austria where I work, There was an elderly gentleman mowing his lawn near Salzburg in Yodeling, as Austrians tend to do in that area, I suppose. His neighbor was Muslim and called the police and said, "This man is making fun of the call to prayer of Islam." And he laughed, but he lost the case. He had to pay a fine. So this stuff is really happening. It's really happening. And the Arab nations have a very strong lobby at the United Nations. And it's only recently that Christians have gotten involved in challenging this. Freedom of religion in hostile countries, that's something that we can do in any intergovernmental body. There is real persecution happening around the world. There's more martyrs today than ever. And whether it be in Orissa, India, in Myanmar, in Iraq, Iran, Egypt with the Copts, Christians are dying, and we need to advocate on their behalf. Again, hearkening back to what I said at the beginning from Proverbs about defending those who are being slaughtered. We need to engage. And the last is reforming the treaty bodies. Again, I said there's 9 treaties with 9 treaty bodies, all of them working beyond their remit. So these are unelected experts, and no one knows what they mean by experts, who are creating rights in the treaty body. So they're taking these treaties where these nations have battled out for weeks, months, and sometimes years, and crafting language that's fair for everyone. So again, sexual and reproductive health, not defined as abortion anywhere. Yet these treaty monitoring bodies are defining it as abortion and are holding countries to task for not implementing abortion. So we need to reform them as well. Now, lastly on this section, before I briefly get into the issues that we should be concerned about, the European Committee of Social Rights. Does anyone know the difference between the ICCPR, the International Covenant on Civil and Political Rights, and the International Covenant on Social and Economic Rights? It's not subtle. The ICCPR is really the fundamental human rights, right to life, freedom of speech, freedom of religion. The economic and social document is basically social rights, right to a fair wage, maternity leave, education, things like that. Both of those charters have complaint mechanisms. Europe has a great mechanism called the European Committee of Social Rights. So most of us know about the European Convention of Human Rights. Well, the European Social Charter is the second great document of the Council of Europe. And their complaints mechanism is perhaps the best and the worst in Europe. I say that because it's the one European mechanism that doesn't require exhaustion of domestic remedies, but they have a huge scope of power in defining what the European Social Charter means. So, for example, this case that was brought against Sweden can define now for all of Europe a right to conscience without ever having to go to a Swedish court and without having a concrete case. But it cuts both ways. Our opponents use the same committee to try and create radical sexual education and things of that nature. And we've been successful in stopping them there. But it's a venue we should all look at. So to close for my last 10 minutes, and then we'll open up for questions, I'll just talk about 5 issues that I think are the issues that we need to be aware of as Christians. Anti-discrimination, Lord Mackay talked a great deal about that, so I'll just touch on it for a minute. These were really sympathetic cases. Lillian Lidelli was a marriage registrar, and I say was because she's no longer, for more than a decade. She had been working there for more than a decade in Islington Council. She had 20 staff members, or 20 other registrars working there. And when she heard that same-sex civil unions were being legislated, she asked respectfully her counselor to accommodate her religious faith not to have to participate in these ceremonies. Now, that made up a de minimis part of her work, a very small part of her work, and with 20 registrars on rotation, it would have not been a problem to accommodate her. Instead, she was treated poorly to the point of being pushed out of work. I'm told by our friends at Christian Institute who were handling the case that her health as a result has been terrible with all the media scrutiny, and she was the only client who wasn't able to attend the oral hearings in Strasbourg when they happened last year. Gary McFarlane, he's an elder in his church. He was a lawyer, and he repented from that and became a marriage counselor. No one ever laughs at that joke. Repented for being a lawyer. All right, well, anyways, he became a marriage counselor, and the question of would he do his services for homosexual couples came before him. It's a hypothetical question. It wasn't, again, there was no actual client being discriminated against. He said, look, as a matter of faith, I can't perform psychosexual therapy for same-sex couples because I'd be promoting homosexual behavior. And if you think about it, therapists, just like any other medical professional, refer clients all the time. If you're going on a vacation, you refer your client to another therapist. If there's a conflict of interest, you refer. If it's not your area of expertise, you refer. No problem. Why couldn't he refer? He was fired for gross misconduct for simply asking the question. Gross misconduct basically is given for only serious moral turpitude. So violence in the workplace, for example, fraud, that level of misconduct. He has become unhirable as a result of this. The cases went to Strasbourg, and the court came up with this really willy-nilly judgment on how to describe anti-discrimination. And the good news is there was 4 cases combined. Everyone is familiar, I'm sure, with the British Airways case, the Cross case. Nadia Rita, she won. And that's a historic victory because it's the first time the UK has ever lost an Article 9 case, so we should be pleased about that. We should be pleased that the court has said that this UK argument that the right to religious freedom means the right to quit your job is frivolous, because actually they had taken it from the European Commission, so it was something that was recycled by them. And by the European Commission, I mean the old court before the permanent court was set up. So they said there is a right to manifest your faith in the workplace, and there has to be a balance between that and the rights of others. Where it breaks down is that the court also said that there is a wide margin of appreciation given to the member states. So good news in places like Lithuania, where religious freedom trumps sexual orientation. Bad news in places like the UK, where it's vice versa. So when you have the bulls, these bed and breakfast owners that Lord Mackay was talking about, under this jurisprudence, they'll lose. We were pushing very hard, and will continue to push very hard for the doctrine of reasonable accommodation. And we feel that, judicially speaking, that is the way to go, because when you say that you can only interfere with religious liberty when it's necessary in a democratic society and proportionate, well, a balancing test doesn't cut it. Because obviously, if in the case of Miss Liddell, when you could easily have rescheduled her, it wasn't necessary in a democratic society to restrict religious liberty. Again, in the case of Mr. McFarlane, when he could have referred without any client being aware of it or hurt, that was an easy accommodation. Reasonable accommodation is that when someone has a sincerely held religious belief, it is respected by the employer unless it causes an undue business hardship. It leaves very little guessing room for the judges. It's really a bright line rule, and what they have now is really unacceptable. And so unfortunately, for the time being, we are under the tyranny of anti-discrimination law until the next big case comes and overturns these decisions. Conscientious objection is the second point I want to talk about. That's really related. Conscientious objection can also be served by reasonable accommodation. It says that if you have a sincerely held religious belief, you should be able to manifest it in the workplace. So your physician who refuses to perform an abortion, your medical researcher who won't work with the destruction of the embryo, your registrar who doesn't want to perform a same-sex civil union, or your French mayor who doesn't want to perform same-sex marriage. These are all people who, under reasonable accommodation, would not have to do so. Europe is at a real crossroads on this issue. The European Court of Human Rights, in a case called Batayan v. Armenia, held that there is a right to conscientious objection in Europe. It was in the context of military conscription, but it suggested that it goes wide beyond that. Why it wasn't implemented further in Liddell and McFarlane, I don't know, but it's something we need to fight on. Freedom of expression has an interesting history. Every European Union country has a hate speech law. And the irony of hate speech laws is when they were drafting the ICCPR and the Universal Declaration of Human Rights, there was a massive debate between America, Canada, UK, France, the Western countries, and the former communist countries. Former communist countries wanted hate speech implemented into both the Universal Declaration of Human Rights and into the ICCPR. They failed with the declaration. They had some moderate success with the ICCPR. Now, again, with how topsy-turvy the world has become, it's these countries now who were defending the right to freedom of expression tooth and nail back in the 50s and 60s who were the biggest proponents of hate speech legislation. So you have people being criminally fined for yodeling. You have an Irish bishop who a complaint has been filed against him because he offended an atheist because he said Ireland was a godless place. You have a family channel in Spain being fined $500,000 for showing actual footage of a gay pride parade. Actual footage. Nothing off the wall, just actual footage. Ake Green, of course, is a famous case where a pastor was sentenced for inciting hatred. He got off at the Supreme Court, but he had faced 6 months in jail. He's the one we know about, but he's not the only one. Street preachers in the UK are being arrested practically monthly or every second month. 2 bishops in Belgium were criminally prosecuted. They didn't lose the cases, but charges were brought against them for criticizing homosexual behavior, as was a Spanish bishop. So this stuff is happening. It's real. This is a huge chilling effect on our ability to spread the gospel. A case in Sweden, Bedslund v. Sweden, which was heard by the European Court of Human Rights, really changed the game in a negative way. For decades, the court had said that freedom of expression means the right to shock, offend, and disturb, because what would freedom of expression be if it only allowed you to share ideas that were favorable to everyone? And I believe that to the hopeless sinner, there's the gospel song, that there's no hiding behind the kingdom throne. That to many sinners, the gospel is an obnoxious, terrible, awful thing to hear. It's certainly shocking, offending, and disturbing, and we should have the right to do it. But this case held that, and I'll quote the language of the judgment, that while the particular speech in question did not directly recommend individuals to commit harmful or hateful acts, the comments were nonetheless serious and prejudicial. So again, judges no longer have any clear guidelines on how to define speech, and it ends up in the hand of the individual activist judge to say what is protected speech and what is not protected speech. And to give you an idea of how absurd this is, I mean, who in this room would be comfortable in saying that certain speech is protected because it shocks, offends, and disturbs, while other speech is criminal because it has serious and prejudicial allegations? They sound like the same thing. So it's really up to the arbitrary judge. And closing on the freedom of expression, I just want to quote the blasphemy law in Pakistan. And I'll tell you why in a minute. It says that whoever, with the deliberate intention of wounding the religious feelings of any person, utters any word or makes any sound, so you'd have yodeling, I guess, in there, in the hearing of that person, or makes any gesture in the sight of that person, or places any object, a Bible perhaps, in the sight of that person, shall be punished. Now this can mean absolutely anything. It's completely subjective. People can make up claims all the time. We say, well, that's Pakistan. What do you expect? That's also the law of Cyprus. This stuff is coming our way. And we're helping defend Pentecostal in Greece, who's been sentenced to prison for bringing his neighbor to Christ under the anti-proselytism laws. So this stuff is real, and we need to be challenging it. And the last part I want to talk about was church autonomy and registration. Europe is becoming increasingly hostile to churches, and the state is taking on too much authority in governing churches. An example is Hungary, which is not too far from here, where they created a new law on religions where they automatically deregistered the majority of religions. Now, the irony of that law is, in a really ad hoc manner, they chose a number of religions who didn't have to re-register. Those who didn't meet any of the formal criteria that would have allowed them to re-register, were given the right to remain as churches, whereas a number of churches and paraministries, something like Campus Crusade, would suffer or has suffered under this law, can no longer re-register as churches. So they lose their tax-exempt status. They lose their right to own and acquire and safeguard property. They lose their legal personality. Stuff they've enjoyed, in many cases, for decades. It's at the European Court of Human Rights now. In Romania, you have really, on occasion, this really tight relationship between the Orthodox Church and the state, which on occasion runs amok, and the victims tend to be evangelicals, Baptists, Pentecostals, Greek Catholics, many who had property taken during communism, and when it came to time for repatriation, instead of going back to the rightful owners, they were given to the Orthodox Church. And there are cases at the European Court of Human Rights now where we're litigating where they're not even allowed to use their own cemeteries. So this is really statism at its worst. And we have 15 more minutes. If you could just give me 2 more minutes on parental rights, it's the last topic I'm going to talk about. It's kind of the most shocking one because it hits everyday parents. It's not just for Christians, although most of these cases, all the cases we deal with are Christian cases. 14 parents in Germany had 7- and 8-year-old children who were told that they had to go to sexual education classes, 3 days of sexual education classes. So no science, no math, no geography, nothing taught except sexual education. The centerpiece of these 3 days was a interactive sexual education play. So these parents reviewed the curriculum and said, no way, we're keeping our kids at home. All 14 of these parents have served jail time for that decision. Some of them 40 days, mothers, fathers, all of them. In Germany also, I represented Melissa Buskross, who, when she was 15, had failed 2 of her classes. She got A's in all of her other classes, but had one class in particular, same teacher, same disruptive environment, where she failed. And the school wanted her to repeat the grade, which would have basically meant that she had no chance of getting into a top-tier university. She could go to a vocational university, maybe. Her father was a pastor and decided, we're going to home educate her because we're not going to let her suffer because of one bad teacher. That decision led a court to order 8 police cars to surround their house at 6 in the morning. They took Melissa away, this was in Nuremberg, to the Nuremberg Mental Institution. She tried to climb out of her window to escape, 15-year-old girl. And she was committed for school phobia. Even though she'd attended school, she was 15 years old. For school phobia, she was committed for a number of months and then put into foster care after that because they said the parents enabled her for school phobia. In Sweden, we have similar stuff happening. We have a case where a missionary family was moving to India, wanted to home educate. The police came on board as they were flying from Stockholm to India, took their son Dominic, who was 7 at the time, away from them. It's been 3 years. 3 years they have lost custody of their child. No physical abuse, no mental abuse, no neglect. Their only crime was home education, wanting to give their child the best education they could as missionaries. So the state is trying to really steal the hearts and minds of our children. The belief in many countries here in Europe is that the only role of the parents is to give birth to a child, and then they take over. Opt-outs aren't being given. The education is becoming more and more radical, and your ability as parents to home educate, which is a staple in a lot of democracies, is being met with criminal charges or with children being taken away. So the challenges are many, and so I encourage everyone here, although it's not precisely the topic I was asked to talk on, I think as Christians we should all be informed of these issues and engage on some level. So I'll open up for 12 minutes.